following program on Ada Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we delve deep into the laws governing privacy in Sri Lanka. With the introduction of the Personal Data Protection Act, Sri Lanka has held itself to a new standard of the right to privacy. However, discrepancies continue to arise in relation to the consequences of its invasion. How does the law set out protections and penalties for the infringement of privacy both on and offline? A very good evening and thank you for joining us on another episode of Law, Land and Liberty, where we break down the fundamentals of key events in the legal sphere and give it to you, the layman. Now, today we have with us a topic that I'm sure a lot of us have thought about with the recurrent, with the day and age that we're in, with technology taking over every aspect of our lives. The concept of privacy and the invasion of privacy is a very controversial topic that I'm sure a lot of us have had conversations in whichever sphere we dabble in. Now, the fact that privacy does not have set regulations and it's not one single solidified act is it's a point of contention for a lot of us. So to speak about privacy and the ins and outs of privacy and basically the fundamentals of privacy online and offline, we have with us a very notable figure in the field, and that is Mr. Thishya Weragoda, attorney at law. Thank you very much, sir, for taking the time to speak to us. So before we begin with the program, here is a small breakdown of exactly how the discussion is going to flow. First, we'll be talking about the fundamentals of privacy. What really is privacy, essentially? Next, we'll be talking about privacy in different settings. So privacy in the home, privacy in public spaces, privacy online, privacy offline. And then we'll be going into possible international parallels and also opinions on the privacy aspect, the protection of privacy aspect in the end.
Hello, my name is Thishya and I'm a law student. My question is on fundamentals of privacy. What is privacy and what laws govern the right of privacy?
All right, well, without further ado, let's get right into the discussion. Sir, thank you very much once again for speaking with us. Sir, well, let's not beat around the bush and let's get right to the point. Now, a lot of us might have somewhat of an idea of what privacy could be, but could you explain to us in legal terms and in the legislature what essentially defines privacy? What is privacy?
So, in terms of a law, there is no specific statute that says this is what privacy is. Now, if we take the fundamental rights chapter in our constitution, we know what freedom of expression is, we know what the freedom from being arbitrarily arrested is. But the law does not say that there is a fundamental right to privacy. So similarly, in our law, we do not see a definition to the word privacy in a statute book, except maybe in the Personal Data Protection Act, which was passed last year. Leaving that aside, we do not have a specific law that says this is what privacy is. But if we really think about it, what is meant by privacy is the right of a person to be left alone. So for example, it's sort of like this aura that surrounds us, a sphere, invisible sphere, which protects us. So to say that, okay, my right to privacy means A, my right to be left alone, and B, my right not to be discussed in certain situations. So we can say that. So that would include, for example, what is in my mobile phone, or a confidential communication between myself and a client, a doctor and a patient, between husband and a wife. So there are some examples between a father and a child, or a parent and a child, that sort of situation, or between an employer and an employee. There might be a situation where what we do is not the business of someone else. So this concept of privacy, what we are trying to protect is that sanctity. So basically something that is surrounding us, it is not a physical body, but something that is a little bit further away from us. So that's what we are trying to protect in terms of what we call privacy.
I see. So that's the fundamentals of what exactly privacy can be defined as, despite not having a set definition in the legal sphere in Sri Lanka at least. So moving on, sir, now I think we should go into the legislative aspect of it, because that is how we continue with the understanding how privacy is protected and the right to privacy in the law. So could you tell us a little bit about what key pieces of legislature really mention privacy or the right to privacy? So
the right to privacy, I would say, the only law that talks of it is the Data Protection Act, which was passed in 2022. So other than in that, there is no specific mention of any right to privacy in our law, in the sense in any statute book. But if we look at what we call the common law, the Roman Dutch law that governs the general law of this country, there is ample text that says that certain things are considered as privacy. For example, somebody can't just, for example, a police officer can't just arrest you or say, give me your phone, I want to see what is inside it. Because that would be a breach of my privacy. But unfortunately, we hear on news that so many people have been arrested for having maybe obscene publications in their mobile phones or some sort of thing like that. But you can't really do that. That is a concept that is alien to our law. So if you talk about it, if you think about it, what we consider as our privacy, the common law will generally protect it. So in the Roman Dutch law, which is about 600-700 years old, obviously the present day problems were not there. But what has happened is that in the interpretation of whatever those provisions in the classic text, judges have basically added on. So for example, in the early 1900s in South Africa, a judge held that if a wife is followed by a private investigator for purposes of proving adultery, that could amount to invasion of privacy. But of course, in the modern day, I don't think that will hold, because if you're followed in a public space as opposed to a private space, so let's say somebody follows you on a street, the following would probably not constitute as a violation of privacy. But if somebody tries to record you inside your car without consent, that might amount to an act of violation of privacy. Similarly, if we say, for example, you are under an umbrella in Galle Face and somebody takes a photograph, you can't really say that that is a violation of privacy. But, because you're in a public space. But on the other hand, if you really think about it, you are trying to cover your face and somebody tries to take a photograph of you. Even though you're in a public space, that might still constitute as a violation of privacy, because by you trying to cover your face with an umbrella, you're trying to tell people that I'm expecting some degree of privacy. Whether that is right or wrong or acceptable might be an issue that we need to look in detail probably in a trial. But generally that's the concept. So in a public space, there is no general principle of privacy. You're on a road, you can get recorded unless you cover yourself with a mosquito net or something so that you can't be identified. But on the other hand, there may be certain specific situations where you would say that, no, there is an expectation of privacy. For example, a case in the early 1930s in the United States. This lady, she had gone to the country fair. And while she was there, she had been photographed. But she had been in a short dress, which, because of the wind, had gone up, and a photographer had taken a photo and published it. That publication was considered as a violation of privacy. Because even though she was in a public space, when a very compromising photograph was taken, that violated her privacy. So the idea is that generally in public, you don't have a concept of privacy, but there might be special situations in which you will still assume that there's a reasonable expectation that there would be some sort of privacy.
So when it comes to drawing that line in, public spaces, considering the invasion of your personal privacy, how does that translate in the legal concept? Now, you mentioned, sir, that under Roman Dutch law, over the time passing, it has evolved, and we've seen how judges have added on. Is it purely through that aspect alone that we are now governed, and how we are told that this is an invasion of privacy and this is not?
So basically what has happened is that Roman Dutch law essentially is judge-made law at the end of the day. So if we wanted a statute saying this is our privacy, then there has to be something from Parliament. So if you look at countries like the United States, the United Kingdom, you will find laws that says this is privacy and this is not. For example, if somebody tries to attach a spy cam inside a washroom in the United States, there are laws that says that you are committing an offense. Not just that it is a violation of privacy, where you can sue for damages, but the person who does it might end up in jail. But in Sri Lanka, you don't get either side of it. But I think the important aspect we need to understand is it will always be a case-by-case situation in the modern world where judges would have to decide whether this falls within the concept of privacy the Roman Dutch law had, and whether that is something that needs to be extended. So for example, there was this case that we are aware of, where a wife decided to hack into the husband's phone and take screenshots to be used as evidence in a divorce proceeding. And on the first instance, the court looked at it and said, yes, these should not be published. And the publication would be a violation of the husband's privacy. But if that information was found by following that husband, for example, then there would not be any violation of privacy. So I think the idea is that you can't do something that is immoral or wrong on your own in order to find some information. So I think that is the line, a very thin line that we can probably understand as this is where privacy ends and this is where privacy begins.
I see. So it is treading a very thin line when it comes to the classification of certain invasions of privacy, what is and what's not. Now, sir, previously you mentioned a little bit on everyday examples of a breach of privacy. Could you just give us a little bit more of an in-depth look into certain examples, what we can classify as a breach of your privacy and what is not, so that our viewers can understand?
Certainly. In Sri Lanka, I don't think we have very many cases which has gone up all the way to the Supreme Court on this little issue. But world over, privacy is a serious problem, especially if you are a celebrity or something like that, where you get paparazzis following you and all of it. So in the United Kingdom, I think it was in the early 2000s, Naomi Campbell walked out of an Alcoholics Anonymous meeting. So as the name suggests, it's supposed to be anonymous and nobody's supposed to judge you. And when she walked out, there was a paparazzi who took a photo and published it in one of their tabloids. And then she litigated against this tabloid, saying that you violated my privacy by publishing me walking out of a Alcoholics Anonymous meeting. And then finally the highest court, the House of Lords at the time, basically Lady held that that is in fact a violation of privacy, although she was on her main road. Because she was walking out of a place where there was an expectation that there will be some privacy. Because as the name Alcoholics Anonymous suggests, you are not supposed to be identified. You consider that as a place of a sanctuary, basically. So when you walk out of that and you get photographed, obviously that sanctity is challenged. So in that situation, it was held that it is a violation of privacy. So that had far-reaching consequences. So I think in the modern day, if we really think about how the law would be interpreted now, if something of that sort happens in Sri Lanka, I think then the same principle would be applied. Similarly, I think we have situations, especially during COVID, where there were situations where camera crews sometimes entered into homes, things like that. I think those are also situations where if we really apply the principles of privacy, because they were COVID patients and because there was so much of stigma attached to it at the time, that sort of behavior should not have been put in place. But unfortunately, that's how the cookie crumbled back then. So similarly, I think there was this other incident recently also where people had walked in on some individuals who were having some sort of romantic situation in some private confines. That sort of situations also, I believe, it's the same principle that applies, especially when you're in your own home. There is a sanctity that is attached to it. When you're in your car, there's a sanctity attached to it. So I think we need to understand that as a principle, there is sanctity attached to it. If you feel that I need to be protected in this situation, then probably that's where the line has to be drawn.
I see. So that is a very clear demarcation, and it's very clear to follow as well, considering where it's a case-by-case basis.
Of course.
And it all depends on the context.
And also, if I may add, especially because we now have mobile phones with cameras, everybody is a journalist. Everybody can publish, especially on Facebook, Instagram, you can go live, all of that. So we must always be very conscious as to whether we are violating someone's right to be left alone. That's the important.
Exactly. So there's a level of introspection when it comes
absolutely,
to
because
that,
on the one side, you have your freedom of expression to record and publish. On the other hand, the other person has a
right to privacy.
A right to privacy.
Exactly. So there is a lot more to discuss regarding the nitty-gritties of the right to privacy and how it differs in different settings. But before we do any of that, let's go in for a very short commercial break. You're watching Law, Land and Liberty. Stay with us.
My question is on privacy in different environments. How is the right to privacy upheld in private and public settings?
Welcome back to Law, Land and Liberty. We were in conversation with Attorney at Law Thishya Weragoda. Now, sir, we spoke very briefly on we touched on basically how privacy is defined and how it differs in different contexts and different settings. So I think it's it's a good segue for us to get into this segment as well, considering the difference between personal privacy in different settings. So when it comes to civil areas and also public law areas, now there is a difference. So if you could, sir, explain to us how it contrasts and where exactly the demarcations are when it comes to each area, I think it would be a very insightful take on that specific topic.
So if we look at it, there are interactions between individuals. So for example, there is a expectation of privacy between you and I, which requires me not to poke my head into your mobile phone and look as to what you're typing, because you have a right to privacy. So if I violate that, then there may be consequences. But that is a civil wrong. So we would go to the district court and file action. So for example, if maybe say romantic partners exchange private, intimate photographs between themselves, and one partner decides to share them elsewhere, that would also be a violation of privacy. Or for example, I have a conversation with a client, and without my consent or without my client's consent, somebody taps into it. All of these are situations, or a doctor and a patient, for example. Or let's say two individuals, they're cracking a joke about something, and then someone records it and publishes it without consent. Or, like I said earlier, some people are inside a hotel room having a drink or whatever they were doing. As long as there's no crime being committed, nobody can barge in, record it, and just upload it. So all of those sort of situations, we are talking about the civil law, where individuals can be stopped from publishing something else. So that is because of my right to be left alone, because I am inside the confines of my house, or I am within a particular space within which the expectation of privacy is there. So that is one sort of things where you go to the district court and you file action, you get an injunction or an enjoining order. to prevent these sort of infractions from happening. Then we also get situations where the criminal law or the public law kicks in. This is mostly when we have situations of, for example, police investigations or some sort of other criminal investigation. We always hear of individuals being arrested and then brought before the police. Investigations are done. Your computer, your mobile phone, everything is taken away for purposes of investigation. And then what happens is your most intimate private details that are on that phone goes into the hands of some police officer somewhere. So for example, in the Computer Crimes Act, it says that how that sort of device must be dealt with. But unfortunately, we have seen over and over where that process has not been followed. For example, if your mobile phone is taken by the police, you are entitled to ask for a copy of the data, a data backup. Now that's for two reasons. One is to ensure that the integrity of the data. Two is to ensure that you can continue with whatever you're doing. But unfortunately, we see sometimes that there may be situations where the data could get compromised. I won't say that they have been compromised, but they could get compromised. So that is a serious risk. And also, we are sometimes asked to give the password, for example. Now, I would say without a court order, you are not required to give the password. Of course, that does not mean that if you're in such a grave and threatened situation, you can hold on to your guns and say no. But generally speaking, that is the situation. But also, we may have situations where, for example, the police officers or some other kind of officers who are involved goes through all of that information that is in your mobile phone. And essentially, mobile phones are now part of our thought and conscience because our most deepest, darkest secrets might be in there. So there is a requirement that some sanctity is attached to our digital devices. So our personal, the right to be left alone now includes our mobile phones or our digital devices. So this is something that we need to really think about. We need to be conscious of that no one else can access it without consent. Of course, we see in our country, especially given how things are, between spouses, for example, there is an understanding that each other's passwords are shared, so on and so forth. So without that consent, if access is being made, I think there again is a violation of privacy. So the underlying thread that connects all of this is that sanctity that you attach to this is my sphere, this is my space, don't encroach upon it.
I see. But now, just picking on what you just mentioned, sir, you mentioned that in domestic situations, there could be where there's a shared understanding, while unspoken, that some passwords are shared, some accounts are used on two different devices. Now, the mobile phone has essentially become an extension of ourselves. And protecting such a sanctity with conflicting interests, like the conflicting actions where there is a shared password, how does the law approach issues like that, where there is somewhat of an unspoken understanding of shared information, but they still claim that there is a form of sanctity on their physical devices?
So I would say that if it is shared, then it is only those two persons who are entitled to that, keep that information private. Those individuals can't share it elsewhere. So for example, like I said, if two people share their intimate photographs, just because that relationship has ended does not mean that you can go and share it on a WhatsApp thread, for example. That sort of behavior is, I would say, criminal as well. But more than it being criminal, it violates that right of privacy. So a person who is affected by such a situation could always go and file action. Recently, there was this incident which we came across. There was a fake account on a social media which was editing, modifying, and sort of distorting an individual's photo with so many horrendous photographs, and then publishing them on social media. So that sort of situation would obviously mean that the privacy attached to that individual is obviously affected. Now, for example, it could be a situation where you or I post a photograph on Facebook, for example. and then that photograph gets taken and is distorted, modified, and then republished somewhere. That would also be a violation of privacy. Or for example, my photograph is available on, let's say, on Google, and then somebody takes it and publishes it somewhere else. Let's say to portray a dead person in some teledrama. That would also be a violation of privacy, because I published it for a particular purpose, not to be portrayed as a dead person. So these are all issues that things that we never think about, but are actual problems individuals may face.
Exactly, and there is always that issue of where we draw the line personally and where we're supposed to be legally drawing the line as well. And there's always the conflicting issues where we know we've shared with a certain individual, but there has been a breach of privacy. But can we really consider it a breach of privacy when we talk about the closeness of the relationship? And there's a lot that comes into play when it comes to the definition of privacy. And this segment, I believe, has adequately provided a little bit of an outline of how privacy can relay in different settings. Now, we've come up to time on this segment, but join us again in the next segment. We're going in for a short commercial break. This is Law, Land and Liberty. Stay with us.
And I'm an undergraduate at SLEX. My question is on data protection and penalties. How is data protection approached in the current context?
Welcome back to Law, Land and Liberty. We were in conversation with attorney at law Thishya Weragoda. Now, we were talking before we left in for the break about how privacy relates in different settings and what can count as an invasion of privacy and what does not count, and the context based on it all. Now, I think it's important for us to talk about the aspect that I'm sure a lot of us are waiting to hear about, especially when it comes to data protection. Now, personal privacy and data protection can be considered not two completely separate entities. They are somewhat linked, but I'm sure a lot of us don't exactly understand how these two are contrasted and how it is not one and of the same. So, sir, if you could explain to us now, over the years we've seen a boom in technology as well. So data protection has become a really formidable issue as well, almost on par with personal privacy and other issues, almost actually akin to it. So if you could explain to us, sir, over the years how data privacy has evolved and how that relates to personal privacy.
So if we think about it, 20, 30 years ago, if we wanted to listen to music, we'd walk into a record bar, buy a cassette, bring it home, play it on a cassette player. Then in the late 1990s, early 2000s, it became a CD. And then Napster came around, where you could download MP3s and listen to it on your computer. And then that led to a situation where there was a lot of copyright infringement, for example. And because of that, today, if you look at it, Spotify, Apple Music, Tidal, whatever the platform that you're talking of, all of them require you to register, download music. You give your credit card number, you give your name, you give your email address, and a whole lot of data. So basically they profile you. They know what music you listen to. They know what music to promote to you. So in this setting, we need to, this is just one example, but let's say you walk into a supermarket, you key in your loyalty number, not just a supermarket, you go to any shop in this country now. And then the moment you key in your number, you will get a message, say, with some promotion. So we need to understand that we have sold off for free a lot of our rights. Our right to be left alone. Right? You will get, if you look at your SMSs every day, you will have about 20, 30 SMSs of various promotions. Food to, clothes to, whatever. So this means that we have parted with part of our privacy by signing up for these. So in the world, if you look at it, essentially what the rule is that we as consumers must opt in to getting those messages, promotions, whatever. But unfortunately, in Sri Lanka, we didn't have a law until last year when the personal data protection law came into being. In countries like the United Kingdom, these came around in the late 1980s. So basically what happens is that because of this reason, all these years, our data, our phone numbers, our email addresses, our NIC numbers, all of it was misused. But thanks to the present law, it requires the data collecting person to ensure certain protections to us. And if we write to them and say, please take out my information from your system, the person who is collecting the data is duty bound in terms of the law to remove our information from the system. So in that sense, at least we have some protection now. But 10 years ago, 8 years ago, 5 years ago, we didn't have that protection. So in one sense, we've improved a little bit.
So sir, a little bit of a question now. Do you believe that there are retrospective elements to a recently passed law such as the Data Protection Act?
No, I don't think it is retrospective. But what happens is that data collection and data mining is an everyday occurrence. We walk into a shop, supermarkets for example, the best example. Every time we buy something, we get profiled. So the data protection law says that that profiling should be minimal. That, for example, Thishya Weragoda bought this toothpaste, can't be recorded. They could possibly record citizen X has bought Y toothpaste. So that protection came about only now. Until then, we had no knowledge how our data was collected, how it was sanitized, and how it was used.
Exactly. So now I think the question that we all must be having in our heads is the adequate nature of data protection. Are there provisions that have been awarded now recently? In your opinion, are they adequate for data protection?
So at the moment, I mean, from having nothing, having something is a good thing. But it will take a long time for all these data gatherers to comply with the law, because we are not used to generally complying with the law immediately. I mean, for example, if that was the case, there wouldn't be any police brutality in this country because our constitution had been saying it for the last 40 years. So just like that, I think the important thing we need to understand is just because the law is there does not mean that everything is hunky-dory. It will take a long time before these laws are a part of our everyday life. So until that happens, there will be transgressions, there will be litigation, people will have to constantly go to court and keep on pushing for things. Only then will it change. But this is a good stepping stone. And this is a starting point. So maybe in another 20 years, if we have this conversation, probably we'd be in a much better situation where data protection and personal data protection and thereby privacy of individuals is much better protected.
I see. So there is a long way to go, but we have made a start considering our recent litigation as well. While there isn't a completely clear understanding or completely clear area to which we can refer when it comes to personal privacy and all things related to privacy, there is still a start, and there are areas that we can, as citizens of Sri Lanka, refer to in order to be better aware of our rights and our right to privacy. Well, unfortunately, time has come against us, but I'm sure this discussion was quite an insightful one. Thank you very much for taking the time to speak to us, sir, and to enlighten our viewers regarding what privacy really is and how it is mentioned in the law and what we can do as citizens to ensure our right to privacy. Thank you very much.
Thank you very much for having me.
All right. Well, the information age, seeing an exponential involvement of new technologies, the concept of privacy is not one-dimensional and simplistic. Despite these complications, the law has set out provisions which we must each learn to protect our privacy with. We leave you tonight with the words of Salil Shetty, who is an Indian human rights activist. The question of the right to privacy must be one of the defining issues of our time. That is all from us here at Law, Land and Liberty. If you had missed any of today's programs, you can always rewatch by catching us on our YouTube channel, youtube.com/OtherDerana English. Thank you for watching. Have a great night.